everyone, I am Miss Jane Borja, registered criminologist. For today, I'll be discussing fundamentals of criminal investigation and intelligence. Before we jump into our discussion, please don't forget to like and subscribe to the professor's channel and hit the notification bell for you to be updated on the professor's new upload. So what to expect from this discussion? So we'll be discussing arrest and search and seizure. So we'll be discussing the legality of arrest, how to make arrest, rules on making arrest, and what are the circumstances to incite lawful arrest, and also search and seizure. Okay, to begin with, what is arrest? Arrest is defined as to taking a person suspected to have committed an act to which the law defines it as a crime into the custody of any law enforcement agencies who has the authority to do so in order to answer queries in line with the matters concerning the commission of a crime. So when you say arrest, it is an act of apprehending, taking, bringing, catching, and keeping a person who is believed to be the one who committed the crime into the police custody. So ito yung kuha at pagdala sa kustodiya ng mga otoridad sa isang taong pinaniniwala ang gumawa ng krimen. So what's the purpose? That is in order for the arrested person to answer the questions in relation to the certain crime. So inaaresto ng law enforcer yung isang tao para ito ay managot or makasagot sa mga katanungan tungkol sa nagawang krimen. So we also have here legal definition of arrest found in section 1, rule 13 of the rules of court. Arrest is defined as the taking of person into custody of law in order that he may bound to answer for the commission of an offense. So the arrested person is obliged to answer questions in relation to the crime which believed to be that he has committed. So there are two modes of arrest. First one is by virtue of warrant of arrest. Second one is by warrantless arrest. Pag sinabi natin by virtue of warrant of arrest, inaresto natin yung tao by means of warrant. So mayroon nakitang probable cause that the person being arrested is probably the one who committed the crime. Pag sinabi natin warrantless arrest, ito yung pag-aresto sa isang tao na walang warrant. Kaya tinawag na warrantless arrest. But it could only be legal upon three circumstances. So meron lang tayong legal circumstances na pwedeng umaresto kahit walang warrant of arrest. First one is in flagrante delicto. Second one is hot pursuit. Third one is when the person being arrested is an escapee, which we will discuss later on. So, okay, what is warrant of arrest? So, warrant of arrest, it is a document from court ordering and directing any law enforcer to apprehend and detain any person whose name will appear in the warrant for him to answer matters regarding the commission of the crime. So, warrant of arrest, this is a writ from the court commanding any law enforcer to arrest and detain a person or keep a person in custody who is believed to be one that committed a crime in order for him to answer matters involving the commission of the crime. So ito yung order coming from the court kung saan nakasaad yung command ng korte na huhulihin yung isang taong pinaniniwala ang gumawa ng krimen. In warrant of arrest, the person to be arrested must be indicated. Kailangan nakalagay dito kung sino yung taong huhulihin. We have this what we call jando warrant. Yung jando warrant is a warrant for the apprehension of the person whose true name is unknown, meaning yung huhulihin ay hindi pa kilala as to identity. Generally, this kind of warrants are void or not valid because it violates the constitutional provisions which requires that warrants should particularly describe the person or persons to be arrested. So, nakasaad kasi sa under the constitutional provision that the warrant of arrest should describe the person or persons to be arrested. But if the description of the identity of the person to be arrested is sufficient in jando warrant, it may be valid. So, any person suspected to have committed a crime can only be lawfully arrested after securing a warrant. So, sinasabi dito na legal lang yung pag-aresto kung inaresto mo yung tao by virtue of warrant of arrest. But as what I've said earlier, there are instances wherein arrest could still be legal even if there is no warrant of arrest. And again, those circumstances are in flagrante delicto, hot pursuit, and when the person to be arrested is an escapee or fugitive from justice. So by the way, this is an example of warrant of arrest. So as you can see, this is issued by the judge, commanding the arrest warrant officer, Archie Timanil, to arrest uh, Romano David E. Minjola. So naka-indicate talaga kung sino yung i-arrest. So what is warrantless arrest? So warrantless arrest is defined as an arrest made by any law enforcement without the benefit of warrant. So provided that the following circumstances are present. So again, pag sinabi natin warrantless arrest, ito yung pag-aresto sa isang tao na walang warrant of arrest but it could only be legal upon these three circumstances. So we have here in flagrante delicto, hot pursuit, and escapee. So first circumstance in flagrante delicto, or what we call caught in the act. So this happens when in the presence of the law enforcer or arresting person, the person to be arrested is attempting to commit, actually committing, or have just committed an act to which the law define it as a crime. So under this circumstance, in the presence of the arresting person, the person to be arrested is attempting to commit crimes, meaning the perpetrator performs an overt act. So when you say overt act, external acts, observable acts, indicating the intention of the perpetrator to commit a crime. So, in it attempting, gagawin pa lang ng perpetrator yung krimen, pero before niya magawa, lahat ng acts to fully consummate the commission of the crime ay nahuli na siya. So, actually committing habang ginagawa niya yung krimen ay nahuli siya, or pagkatapos niyang gawin yung krimen ay nahuli siya. So, those fall under the circumstance of in flagrante delicto. So, when the said circumstance is present, and then in the presence of the arresting officer, the arrest is legal even without the virtue of warrant of arrest. And here the arrest is required to be done immediately. So kailangan yung mismo time na yan nakita mo, arresting officer, nakita mong gumawa ng krimen, arestuhin agad. So common example na in flagrante delicto, by bust operation. So second circumstance is under the doctrine of hot pursuit. So it said here that the person to be arrested has committed an act to which the law defines it as a crime, and the person making the arrest has probable cause that the same person is probably guilty of a crime. So when we say probable cause, simply means as a reasonable basis to establish a well-founded belief that the person may have committed an act to which the law define it as a crime. So, when you say probable cause, it is an actual belief or reasonable grounds of suspicion that a crime has been committed and that a person who is nahuhulihin mo is the one or is probably the one who committed the crime. So, under the doctrine of hot pursuit, the person to be arrested already committed the crime. The arresting person here don't have to actually witness the said commission. So, hindi niya kailangan na actual makita yung execution o yung pag-commit ng crime. But he must have the personal knowledge of the facts and circumstances relating to the crime committed. Meaning, the arresting officer has the reason to believe that a crime has been committed and that the person to be arrested or the person about to be arrested is the one who committed the crime based on the personal knowledge of the arresting officer. So when we say personal knowledge, kailangan ikaw talaga mismo yung may alam, hindi hearsay, hindi mo narinig sa ibang tao. And personal knowledge covers your personal perception. So hindi mo actual nakita pero narinig mo, or hindi mo actual na nakita yung execution of the actions, pero for example, nakita mo tumatakbo away from the crime scene yung isang tao or away from you. So that is under the doctrine of hot pursuit. So pwede mo yung hulihin yung taong na yun under the doctrine of hot pursuit without the legally even without the virtue of warrant of arrest. So, next circumstance, escape, that a person to be arrested is one who escaped from penal confinement. So the arrest here is self-explanatory. So it is necessary that an escapee must be brought back to the prison or jail or any confinement facility where he is serving sentence without any warrant of arrest to be issued again by the court. So trivia under these circumstances. So the law authorizes an ordinary citizen to arrest offenders, and we call that citizens arrest. So yung mga ordinary citizen, they are allowed to arrest as long as um, these legal circumstances are present: in flagrante delicto or caught in the act, hot pursuit, and escapee. Furthermore, inquest proceedings will be done if the person was arrested without the benefit of the warrant. So this is conducted to ensure that the arrest made is legal and in accordance with the law. So if the person arrested without the benefit of warrant of arrest, inquest is being conducted. So the purpose of inquest is to determine the legality of arrest. So titingnan dito kung yung pag-aresto without the warrant of arrest is legal ba, and fall under the three legal circumstances which I have mentioned earlier: in flagrante delicto, hot pursuit, and escapee. So ito lang yung kinukonsider natin as legal circumstances to effect an arrest with even without warrant. So what is inquest? It is defined as an informal and summary investigation conducted by public prosecutor in the criminal case involving persons arrested without the benefit of warrant to determine if the person arrested should remain under the custody and charged accordingly. So who conducts inquest? It's the prosecution. Arrested person shall be subjected to inquest proceedings. So after the person arrested without the benefit of warrant of arrest, the prosecution will determine the legality of the arrest and determine the probable cause. So ito yung tinatawag natin na inquest proceeding. Inquest proceeding should be conducted within the time prescribed in Article 125 of Revised Penal Code, as the person arrested is subject to these hours of detention. So, depending on the gravity of the offense. So, grave felony, so subject, hours of detention, 36 hours. Less grave felony, hours of detention, 18 hours. Light felonies, hours of detention, 12 hours. So, kung ang isang inaresto mo na walang warrant of arrest, without the virtue of warrant of arrest, committed grave felony. So that person is subjected to 36 hours of detention. So if that person, if the prosecution did not find any probable cause uh, that that person arrested really committed a crime, so that person must be released. So it is prescribed under Article 125 of the Revised Penal Code. So again, once the prosecution determine the probable cause, it may now file information to the proper court. Pero kung wala, after the prescribed period of hours of detention, the uh, 36 for grave felonies, 36 hours for grave felonies, 18 hours for less grave felonies, 12 hours for um, light felonies, the arrested person must be released. So we have here rules in making arrest. So in making arrest, the rules of court provides the following guidelines. So number one, we have it should be made by an actual restraint of a person to be arrested. So there is an actual restraint when the person is deprived of liberty. So usually, police officers use physical restraint. So they use handcuffs in conducting arrest and place the arrested person in a confinement facility. Then the other one is by submission of the person to be arrested to the custody of any person making the arrest. So, arrest is also made when the person submits himself to the authorities. So, for example, pumunta siya ng presinto or pumunta siya ng police station para sumuko. So it must be noted that in the event of arresting the suspect allegedly to have committed a crime, the person making arrest should observe, number one, not use any unnecessary force. Hindi dapat gumamit ng dahas or excessive force sa pag-arrest. So example, excessive force shooting an unthreatening suspect while fleeing or escaping. So it is not allowed. So you should only use force necessary to arrest the person. So any form of violence is not allowed. Also, since it may cause the physical evidence to be incompetent and therefore inadmissible as evidence during the court presentation. So any violation of the rule in executing an arrest may lead to inadmissibility of evidence, which that evidence is being procured from the said arrest. Execution of warrant. So after a warrant has been issued by the honorable court, any law enforcer directed to cause its execution shall exhaust all the remedies to arrest the person whose name appears in the warrant. So who issues the warrant of arrest? Only the judge are authorized to issue warrant of arrest. And the officer directed to execute the warrant of arrest should do everything that he can do in order to arrest the person who is indicated in the warrant. So again, execution of warrant means carrying out the duty to find the person whose name was written in the warrant and causes arrest of detention. In execution of warrant, the following must be observed. Number one, warrant can be executed either day and night. So warrant of arrest could be executed at any time of any day and night. And then second one, the person making the arrest shall inform the person to be arrested that the warrant has been issued of his arrest. So are you arresting officer when making an arrest? You should inform your authority and you inform that there is and you inform the person to be arrested that there is a warrant that has been issued for his arrest. And the third one, it must be executed within 10 days from the moment it was received. So yung warrant of arrest must be executed within 10 days. Question, does the warrant of arrest has an expiration? Answer is, warrant of arrest has no expiration. So wala siyang expiration. After the lapse of 10 days from the receipt, within 10 days, the police officer being directed to execute warrant of arrest should report back to the court or to the judge who issued the warrant of arrest. And he will state what are the reasons why hindi na-execute yung warrant of arrest. And that the same court will issue then what we call alias warrant. So itong alias warrant, this is issued when the original warrant is returned in 10 days without being served. Yung alias warrant na yan yung dadalhin ni police officer hanggang sa ma-effect na yung arrest. So again, there is no expiration. Pag hindi na-execute ang warrant of arrest within 10 days, babalik lang ang police officer sa judge to report and state the reasons why arrest was not executed, and then the judge will issue alias warrant. And that warrant remains valid until the arrest is effected. So another question, kailangan ba bitbitin lagi ni police officer yung warrant of arrest kapag manghuli siya? No, it is not necessary. So police officer can still effect an arrest even without a warrant of arrest in their position at the time of arrest. So again, at the time of arrest, it is the duty of the police officer to inform his authority and inform the cause of the arrest or that a warrant that was issued for him. So, however, the person making the arrest shall proceed with arrest of the person even without informing of the cause of arrest or that a warrant was issued for him to be arrested, provided that either of the following is present. So, okay lang na hindi mo ma-inform yung authority mo or yung hindi mo ma-inform yung cause of arrest if this following circumstance is present. So number one is the person flees. So paghuli, pag hindi mo siya paghuli mo sa kanya, nakataka siya. So, tumakbo siya sa papalayo. The second one is the person forcibly resist. So, nanlaban siya. And the third one, it will hamper successful arrest of the person. So, yung mahadlangan ang successful na pag-arrest ng tao, or worst, the action of the person about to be arrested would imperil the life of the arresting person. However, if the person whose name appear in the warrant cannot be located, so hindi makita kung yung hindi ma-trace or hindi makita yung taong naka-indicate dun sa warrant of arrest within the 10 working days upon its receipt, the law enforcer tasked to execute the warrant shall make a report to the judge who issued the same, explaining the reasons for the failure to arrest the person within the time given by the court. So ito yung in-explain ko kanina, after the lapse of 10 days at hindi pa na-execute yung warrant of arrest, dapat bumalik si arresting officer to the judge who issued the warrant of arrest and explain the reasons kung bakit hindi niya na-execute yung warrant of arrest. Search warrant. So in line with the investigation that needs the production of evidence considered as a fruit of the crime or a product of illegal activities, either in the possession of someone within the premise of the house or building or even in the vehicle, requires a warrant. So, yung warrant or search warrant is a requirement in order that the evidence obtained from the possession of a person or within the house or in the vehicle will be admissible in the court. So, requirement yung warrant para maging yung evidence na makuha natin from the possession of an individual will be admissible in court. Pero kung meron tayong tinatawag na warrantless arrest, meron din tayong tinatawag na warrantless search, which we will discuss later on. So warrant, this means permit given by the court for a particular purpose. So, for example, warrant of arrest, yung purpose nito is to arrest a person who is believed to have committed a crime. So, when you say search warrant, so yung purpose nito is to search or to seize properties in relation to the crime committed. So, in criminal investigation, seizure is the confiscation of property or any material, usually fruit of the crime or product of illegal activities to serve as an evidence in the legal proceedings. So, seizure, ito yung pagkukumpiska ng mga bagay na bunga ng krimen or ginamit sa paggawa ng krimen. And it could be used as evidence if legally obtained. So, search, paghahanap ng isang bagay na may kinalaman sa krimen at ito ay maaaring makalabag sa karapatang pribado ng isang individual at para ito ay maging legal, yung pag-search, kinakailangan natin ng search warrant. So, ano yung search warrant? Legal definition, an order in writing issued in the name of the people of the Philippines, signed by the judge and directed to a peace officer commanding him to search for personal property described herein and bring it before the court. So, this is an example of search warrant. So, in warrant of arrest, diba, it should describe the person to be arrested. In search warrant, it should describe the property to be searched and also the place where the search will be conducted. So, for example, here in the image, na nasa inyong screen. So, ayan. These are the properties to be searched. So, naka-indicate dyan. Naka-describe dyan kung ano yung mga items na dapat i-search at dapat i-seize. And also the place where the search will be conducted, a specific place. So, search can't be conducted in the whole area. So, dapat specific lang. So, nakalagay din dito at any time of day and night. So, specific place, rooms C1, C2, and C3 only. So, dyan lang pwedeng mag-search yung police officer. So, naka-indicate din dito, you are further directed to submit a verified return within 10 days from today. So, kailangan bumalik yung police officer na nagkakandak ng search after the lapse of 10 days. So, application and issuance of search warrant. Paano mag-apply ng search warrant at kailan ito i-issue ng korte? So, any police officer can request for the issuance of a warrant provided that there is probable cause as a strong basis for its issuance. So, again, when you say probable cause, that means a strong ground that a crime has been committed or about to be committed. So, search warrant, the same with warrant of arrest, there must be probable cause. And this probable cause must be personally determined by the judge. And okay, and the proceeds, fruit of the crime or property that will be used in committing the crime can be found and located in the place so described in the warrant. So again, in search warrant, it must describe what property to be seized and also the place where the search will be conducted. So any police officer can secure the warrant from, so saan makakasecure ng search warrant? So first, in the court. So, the court who has the territorial jurisdiction over the crime. So, depends on the location where the crime is committed. Second is for compelling reason. So, any court within the judicial region where the crime was committed if the place of the commission of the crime is known. However, if the criminal action is already filed, so naka-file na ng complaint or information, so the application shall be made in court where the criminal action is pending. So kung saan nakapending yung kaso, doon mag-file ng application for search warrant. So who shall issue the search warrant? It is the judge. The judge who will issue the warrant after questioning the complaint under oath and in writing to include the possible witness who may be presented. So the place to be searched must be described together with the properties to be seized. The sworn statement shall be recorded together with the affidavit. So again, yung mag-i-issue ng search warrant is yung judge. Same with warrant of arrest. Yung judge din yung mag-i-issue ng search warrant upon after the judge has personally determined the probable cause. So, composition of search warrant. So, the search warrant shall be issued for the search and seizure for the personal property, which include the following. So, we have here, subject of the offense, for example, drugs or illegal firearms, stolen or embezzled or other proceeds or fruits of the offense. Yung mga ninakaw, for example, used or intended to be used as a means of committing an offense. So yung weapons used for the commission of the offense. So these are the subjects. These are only the subjects that could be seized and that could be searched. So execution of search warrant. In the execution of a search warrant, the person must identify himself and his purpose. So you identify your authority and purpose. If he will not be admitted to the place directed for the search, then he may break any parts of the house. He may break any parts of the house. So, pwede niyang gibain ang pintuan or bintana ng bahay or any possible entrance kapag hindi siya pinayagan na makapasok doon sa lugar kung saan he was directed for search as long as he has the search warrant. So, purpose is to execute the warrant, and next is to liberate himself or any person lawfully aiding in him when unlawfully detained. So, pwede niyang gibain ang pintuan or bintana or any entrance ng bahay for this purpose, to execute warrant to liberate himself or any person lawfully aiding him when unlawfully detained. So, the warrant shall be valid only for 10 days from the date of its issuance. So, ibig sabihin yung search warrant ay may expiration. So, after the lapse of 10 days, ma-expire na ito and it can only be served once, and no search shall be made except number one, lawful occupant is present. If hindi present yung lawful occupant, so any member of his family. And if wala tong dalawa, presence of at least two witnesses of sufficient age and discretion residing in the same locality. Or ito yung tinatawag natin na two witness rule. Okay, so in search warrant, kahit na meron na tayong search warrant, we can only conduct search in the presence of number one, lawful occupant. So, yung nagmamay-ari ng property or area to be searched. Kung wala yung may-ari, pwedeng any member of his family provided that they are of legal age and in sound mind. And in the absence of lawful occupant naman or wala ding membro ng pamilya niya, pwede tayong mag-search in the presence of at least two witnesses of legal age and in sound mind na nakatira din in the same locality where the search and seizure is served. In general, all searches shall be made during daytime. So, i-compare natin sa warrant of arrest. Yung warrant of arrest, it could be served at any time of the day and night. Yung warrant of arrest is walang expiration. Yung search warrant, merong expiration. It should be served within 10 days only. After the lapse of 10 days, ma-expire na yan. Yung warrant of arrest, wala. And then, in general rule, all searches shall be made only during daytime unless it is specified to be served at any time or day of day and night. So, kung naka-specify naman doon sa search warrant na pwede siyang iserve at any time of day and night, pwede siyang iserve at any time of day and night. But generally, it should be done only during daytime. So, thereafter, the officer seizing the property shall give a detailed receipt to the lawful occupant. So, in the presence of at least two witnesses of sufficient age and discretion residing in the same locality. So, yung police officer ay bibigay ng kopya doon sa lawful occupant and the properties being seized in the presence of at least two witnesses. The officer making the arrest and seizure shall deliver the property to the court who issues the warrant together with the inventory of the seized items under oath. So, if after 10 days the warrant was not returned, the issuing judge shall summon the person to whom the warrant was issued and allow him to explain why no return has made. So, after 10 days, if hindi pa rin nakabalik yung police officer, pwedeng patawag or pa-summon ng judge yung police officer whom who is tasked to execute search warrant and allow him to explain. The return of the search warrant shall be filed and kept by the custodian. Shall kept by the custodian of the logbook on search warrant who shall enter therein following. So, number one, date of return. Number two, result of the search. And number three, action of the judge. So, question, is there warrantless search? Yes, there is. So, if there is warrantless arrest, meron din tayong tinatawag na warrantless search. So, the Constitution does not forbid warrantless search. It only forbids unreasonable search. So, warrantless search and seizure of personal property based on probable cause made by a police officer without warrant. So, this is true in cases of exigent circumstance. So, what is exigent circumstance? Refers to a situation whereby securing a warrant would make it less practical or useless. So, ito yung mga sitwasyon kung saan hindi na necessary na mag-secure pa ng warrant, search warrant, or the use of search warrant is useless. So we have here search incidental to lawful arrest, search seizure in plain view, stop and freeze, consented warrantless search of a moving vehicle, and tip information. So number one circumstance that is search could be valid or legal even without a search warrant, search incidental to lawful arrest. So search incidental to a lawful arrest, search and seizure of property made by any police officer upon the valid arrest. So the search and seizure of personal property is allowed by the law, provided that the arrest was made by virtue of a valid warrantless arrest. So here, under this circumstance, search and seizure is allowed, provided that it is incidental to a lawful arrest. So again, um, lawful arrest could be conducted either by virtue of warrant of arrest or under the three circumstances of warrantless arrest. So, to be valid, the search must be conducted at the time of the arrest or immediately after and only at the place where the suspect was arrested. So, para maging valid yung search mo, so it should be conducted right after nung pag-arrest mo. And doon mo lang gawin, doon sa place kung saan aresto yung suspect. So, dapat lawful yung arrest. So, in case arrest is conducted without warrant of arrest, the arrest should fall under the legal circumstance. Again, in flagrante delicto, hot pursuit, or escapee. Second circumstance, search may be valid even without search warrant, seizure in plain view doctrine. So this refers to the confiscation of embezzled or stolen property, or where the property is an evidence of a crime or will be used in committing an offense in the presence of a police officer in plain view. So objects that are illegal, or even if not particular prescribed in the search warrant, may be seized under the plain view doctrine. So the requirement of this warrantless search is that items to be searched and seized must vividly and clearly seen, and that the same item is or are considered as evidence of criminal activity in criminal proceedings. So tinawag na plain view. So plain view means the evidence is plainly visible to the police officer. Stop and frisk. Third circumstance. So stop and frisk refers to the brief stopping of an individual made by the police based on reasonable suspicion among persons suspected to commit a crime or in possession of a dangerous weapon. So reasonable suspicion is in lower grade that of probable cause. Reasonable suspicion may be referred to as justifiable suspicion that the person is armed or dangerous. And by the way, stop and frisk rule is otherwise known as Terry doctrine. So, this circumstance, stop and frisk, happens kung ang isang pulis ay nagsususpetsa ng isang individual ay may dalang armas or dangerous weapon. So, there must be reasonable suspicion. So, under this circumstance, the police officer may pat the suspected person for weapons, but is limited only to outer clothing. So sa labas lang. So the police officer has the right to stop a citizen on the street under this um, stop and frisk rule, pat him for weapons whenever he observes unusual conduct which convinces him that the criminal activity exists. Consented warrantless search. Consented warrantless search is a search conducted upon voluntary consent given by the person exercising authority over the property or by the rightful owner. So in consented warrantless search, necessary dito na malaman, na alam ng taong nagbibigay ng consent, alam niya yung karapatan niya. So the person who gives the consent must know his right. Alam niya yung karapatan niya. And given that the said person or the owner of the property to be searched is of sufficient age and in sound mind, gives voluntary consent to the police officer to search in the former's private property. So, sa consented warrantless search, so again, necessary na alam ng owner yung karapatan niya. and he gives voluntary consent to the police officer exercising search. So all the properties or items that is illegal, that could be seized by the police officer, could be used as evidence. So, pwede yung magamit na evidence because under this circumstance, consented warrantless search, it is legal because the owner gives his voluntary consent. So, next is search of a moving vehicle. So in searching a moving vehicle, law enforcement officers are limited only to visual search. So this means that neither the vehicle should be completely searched nor the person should do body search. So ibig sabihin, under the circumstance, bawal yung thorough search sa vehicle. So search in the vehicle should be superficial only. So hindi pwedeng pumasok doon sa vehicle at mag-search yung police officer, hindi din niya pwedeng buksan yung trunk ng sasakyan para mag-search. And also, body search is not allowed. So, example of search of moving vehicle, checkpoints. The extensive search and seizure of a vehicle stop will only be constitutionally valid if it will be done by police officers who had probable cause to believe the driver is a law violator. So his vehicle contains some evidence of a crime or is suspected to commit a crime. So valid lang yung thorough or complete search if of the vehicle, if the police officer has this probable cause or has the probable cause that the driver had committed the crime, and that the police officer believes that the vehicle contains the evidence relating to the crime committed by the driver. Tip information. So tip information refers to the information provided by an informant or any person regarding the commission of an offense, relayed through the cell phone, radio, or telephone to the police who will cause his arrest and seize personal property of the person subscribed. So under this circumstance, valid yung search in consequence of tip information. So, kung meron nag-tip regarding the commission of the crime, along with it describing the person who committed the crime and describing the property used in the commission of the crime. So, pag nag-search ka doon, magiging valid yun under this circumstance. So this doctrine was found on the principle that acquiring a search warrant would jeopardize the arrest of would-be violators. So this is true in cases whereby police officer is tipped by an informant about the commission of the crime. So thank you guys for watching. If you love this video, please don't forget to like, comment, share, and subscribe. Thank you.